A pocket-sized device holds your entire life. It tracks your movements, remembers your conversations, and stores your most private moments. In an era where every tap and swipe generates a digital footprint, a big question comes up. How much of that information is truly yours, and how much is protected from prying eyes? The United States Supreme Court is grappling with this fundamental question. They are constantly redrawing the lines between individual privacy and law enforcement's access in a rapidly evolving digital landscape. It is a complex, high-stakes balancing act that impacts every person carrying a cell phone. For decades, Fourth Amendment protection against unreasonable searches hinged on physical intrusion. Law enforcement needed to trespass onto your property to trigger constitutional safeguards. This changed dramatically with the 1967 case, Katz v. United States. Charles Katz, a sports bettor, unknowingly had the FBI attach a listening device to the outside of a public phone booth he used. The Supreme Court tossed out his conviction, declaring that the Fourth Amendment protects people, not just places. Justice Potter Stewart famously wrote, "What a person knowingly exposes to the public is not a subject of Fourth Amendment protection, but what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected." This established the reasonable expectation of privacy test, a pivotal shift for future cases. Just 12 years after Katz, the Supreme Court introduced the third-party doctrine in Smith v. Maryland. This ruling declared that people generally have no reasonable expectation of privacy in information they voluntarily turn over to third parties. If you give your phone numbers to a phone company, for example, the government could obtain a list of those numbers without a warrant. This principle held strong for years, allowing law enforcement to access many types of records from banks, internet providers, or phone companies without seeking a judge's approval. The legal theory was simple. You cannot expect privacy for information you willingly share, even with a business. The rise of the smartphone presented a new challenge to this established framework. In 2014, the Supreme Court heard Riley v. California, a case involving two individuals whose cell phones were searched without warrants following their arrests. Law enforcement found critical evidence on these phones that led to further charges. Police typically search people and the area around them during an arrest to ensure officer safety and prevent evidence destruction. But Chief Justice John Roberts, writing for unanimous court, made a sharp distinction. Digital data, he explained, cannot be used as a weapon, nor is it easily destroyed once a phone is secured. He emphasized that modern phones contain the privacies of life, a vast, detailed chronicle of personal information. This is far beyond anything a person could carry in their pocket in previous eras. The court held that generally, police cannot search the digital contents of a cell phone without a warrant, even when seized incident to arrest. Just 4 years later, the court tackled a monumental question in Carpenter v. United States. This case focused on cell site location information, or CSLI. Wireless carriers collect and store this data for business purposes, tracing a phone's movements by triangulating its position relative to nearby cell towers. In Timothy Carpenter's case, the FBI obtained 127 days of his CSLI records without a warrant, placing him near several robberies. The core question was whether the third-party doctrine applied here. Did Carpenter surrender his privacy by simply using his cell phone service? In a landmark 5-4 decision, the court sided with Carpenter, ruling that the government generally needs a warrant to access historical CSLI. Chief Justice Roberts again authored the majority opinion. He noted that CSLI is detailed, encyclopedic, and effortlessly compiled, capable of revealing near-perfect surveillance of an individual's movements. The court recognized a world of difference between limited phone records and the exhaustive chronicle CSLI provides. This ruling marked a significant limitation on the third-party doctrine, acknowledging that new technology creates new privacy expectations that old legal theories do not cover. These cases demonstrate the Supreme Court's ongoing effort to balance the vital needs of law enforcement with the fundamental right to privacy in an increasingly digital world. The court acknowledges that technology often outpaces legal precedent, forcing it to adapt the Fourth Amendment's protections to unforeseen circumstances. It is a delicate equilibrium, where the scales constantly adjust to new innovations and societal norms. Finding this balance ensures both public safety and individual liberties. The shift is not without its critics. Dissenting justices in both Riley and Carpenter raised concerns about hamstringing law enforcement and creating unnecessary legal complexities. Justice Samuel Alito, for instance, warned in his Riley concurrence that the majority's decision could create anomalies where physical items can be searched without a warrant but digital data on a phone cannot. In Carpenter, Justice Anthony Kennedy argued that the ruling placed undue restrictions on police powers. Justice Neil Gorsuch even called for the third-party doctrine to be overturned entirely, believing it inconsistent with the Fourth Amendment's original meaning. Despite these dissents, the decisions in Riley and Carpenter stand as significant markers. They signal a clear message. The digital realm offers new avenues for government surveillance that demand robust Fourth Amendment protection. These cases have reshaped how law enforcement approaches investigations involving digital data, emphasizing the necessity of warrants where extensive personal information is involved. It is an evolving story, as the court continues to navigate the complex interplay between constitutional rights and the relentless march of technological progress.